The background given by Ms. Giordano kind of makes my client sound like he's always been some sort of irresponsible sort of person.
Defendant's attorney, Mr. Browning.
Right from the start, notice how the attorney sets the tone. This isn't just legal talk, it's reputation warfare. One phrase, and suddenly the father is painted as irresponsible before he even speaks. Question for you: how much of your identity should be judged by your worst year rather than your decades of effort?
We are here on Ms. Bristol's motion for temporary order. I have read that motion, and as well as the response of the defendant. Ms. Giordano?
Thank you, Your Honor. And like you said, I know you've read this, so I will just be very brief. Just some thoughts based on the response. The primary request here is for exclusive use of the home temporarily. The parties have been married for over 20 years. There's 2 children. My client can maintain the financials to maintain that home pending an outcome of this case. She's working 3 jobs currently to pay the bills. I know that the defendant states that he's going to start working. However, he hasn't worked in a year, and he's made statements like that.
Pause here. 20 years of marriage, 2 kids, and the fight is over who gets the house. But make no mistake, this isn't about bricks and walls. It's about leverage. Whoever controls the home controls the rhythm of family life.
Many times and has not worked. Prior to that, he worked about 10 days for the Rapid last July, didn't show up to work on the next day due to alcohol, was fired. He worked 2 or 3 days at TransDev last August, didn't show up his next day, was fired, hasn't worked since. He did contribute some to retirement. That $50,000 was pre-tax, so by the time it was taxed and penalties, the contributions were something, but significantly less than what he had been bringing in. So my client is doing what she can to make ends meet. Frankly, Your Honor, the environment in this household is just toxic, and it's not good for these children. I laid out an incident that happened in May. Even since then, this week, the defendant
Harsh, right? Every failed job is brought up like evidence in a criminal trial. But let's be real, who here hasn't stumbled at work? Here, though, the courtroom spins it into a permanent stain on his credibility. Fair or foul?
started drinking, and he hid the car keys from my client and wouldn't tell her where they are. This morning, she woke up at 5:50 in the morning. He was in her bedroom. So, it's not a great environment. The children are aware of what's happening. They are aware when Mr. Hart is drinking. They're teenagers. They know the language he uses with them. And we need some separation. We're asking that my client did do some research. She called Guiding Light. They have space for him, and we think he needs some help. He admits to having an issue, and he needs some help. And so in the interim, we're asking that that's where he go, and that my client get exclusive use of the home. We're asking for exclusive use of the cars because, again, the defendant states he doesn't drink and drive. He has DUIs on his record. Just on that May incident, he was clearly intoxicated. The children knew he was intoxicated. The plaintiff talked to him, he was intoxicated. But when she came home, he and the car were gone. So clearly he was driving intoxicated.
Now that's framed to sound chilling, almost like a home invasion. But context is everything. Was he threatening? Was he simply there? The truth is buried under the framing, and courts often don't dig deep enough before stamping it as dangerous.
There has been damage made to a car when he has been gone with it, and my client then found him in the car, passed out with a bottle of gin next to him, and there had been damage to the car. So he does drive. We are concerned about that, and the 16-year-old has a job, and she needs some way to get there when my client is working. So both for safety and for assistance for that 16-year-old, we're asking temporarily for exclusive use of the cars. I think, Your Honor, in terms of the, custody and parenting time, obviously if Mr. Hart is...
Cars, this may seem small, but it's huge. Think about it. Control the vehicles, and you control mobility. That means one parent holds the keys, literally, to the children's schedules, jobs, and freedom. Would you call this safety or strategy?
Getting assistance, I think we can look at what that looks like in the near future. Maybe even the FOC can look at it. But temporarily, I think my client having physical and legal custody of these children so she can continue to parent them and make sure that they get where they need to go and do what they need to do makes sense. Parenting time in the children's best interest, obviously assuming Mr. Hart isn't drinking or hasn't consumed alcohol when he's around him. I also found it somewhat interesting that Mr. Hart is asking this court deny my request for a mutual restraining order that these parties don't verbally harass or assault each other. I mean, if he doesn't think that this is a problem that he might violate, why wouldn't he agree to something like that? So I think that's telling as well. So we are asking that that be entered, and that the children are included in that, so that there can also be no sort of assaulting or harassing of the children as well. I think that covers really most of my requests. We just, we think the defendant has an admitted issue. That issue is making it incredibly hard for this family to cohabitate and incredibly hard for these people to co-parent. And I don't think my client is saying she's perfect, but I think we need a safe and stable environment. And I think temporarily that would assist with Mr. Hart sort of being removed from that household.
Hey, thank you. And I'll just indicate for the record that Mr. Hart is present and was present. He just wasn't on the camera, and I didn't see him when I was introducing the case. Mr. Browning.
Here's a trick. Attorneys will argue that if you don't instantly agree to restrictions, it must mean you're guilty. But remember, restraining orders can become legal landmines. Agree too fast, and you're admitting risk. Refuse, and suddenly it's telling. Heads she wins, tails he loses.
Well, yes, we do oppose some of the provisions that Ms. Giordano.
Mr. Browning, we're having a hard time hearing you. I don't know if you can get closer to the microphone or what, but
Okay, yeah, I'll just.
that's much better. That's much better.
All right, and especially now that we've established that Mr. Hart is present, I guess I don't need to have that wide angle. All right, so to these matters, Your Honor, it is highly unusual for someone to request both of the cars in this sort of situation, and that does seem to be an unreasonable request on our part. She has.
Finally, his turn. But listen closely when a man speaks in court. It's rarely framed as testimony. It's defense. He starts already in the hole, and every word must climb uphill against the accusations already hanging in the air.
Misstated the legal situation. My client did have one OWI. That was in 2016. As far as anything else, that's strictly hearsay. That is that is Kimberly testifying, and I don't think it's appropriate to make the decision that this is what they're asking for is an awful lot here. And I think they're also phrasing it such as they would like the court to order him to move to the Guiding Light shelter. Mr. Hart is capable of finding lodging if he's put out of the home, and I would think that he would probably go to a hotel or something similar.
Important catch here, he admits to one OWI, and that was years ago. Yet in court, one past mistake echoes louder than years of sobriety. Here's a thought, should the law weigh time and progress, or should one record from nearly a decade ago keep haunting you forever?
But again, he is starting another job on Monday, and he would need the card to get there. It is true, apparently, that there is a daughter who might be able to make use of a car, but she could also Uber or Lyft or whatever to work up until, they could get her own car or something else can be worked out. My client, the story, the background given by Ms. Giordano kind of makes my client sound like he's always been some sort of irresponsible sort of person. He was employed for many years. He made just under six figures with the Rapid. It is true he hasn't worked there in about a year, and it's been a struggle for this past year, but he has been contributing. He cashed out his 401k to a certain point, and he's been using that to contribute to the household. He is trying to get help. He has been to rehab 3 times in the past year, but he is an at-home drinker. And their story about him passed out with a bottle of gin, I just don't think that ever happened, and there's no police report.
Notice this moment. His attorney highlights something small: cleaning the house. Sounds trivial? Not in court. When you're labeled toxic and irresponsible, even mowing the lawn or fixing a door becomes proof you're still functioning. Question: should basic chores be used as evidence of parental worth?
Similarly, I don't see much evidence of a real toxic environment because I don't see anything from the opposing party that would show any grounds that she ever found for like a PPO or removal from the home. There was no such incident that could be done that way, apparently. My client continues to function around the home. He just yesterday was cleaning the exterior of the home, which was getting full of mildew. And so he washed it down, cleaned 3/4 of the exterior. And so I also would request that the issue of legal custody not be decided at this early point. I would assume, frankly, that you're probably likely to grant her exclusive use. And so my client is going to need to kind of reorder himself and get a new place. And I would ask that we reserve the issue of physical and legal custody. There is a divorce proceeding just beginning until my client gets a new resident where he can have parenting time.
This is the hard truth of family court. Judges call it temporary, but most parents know temporary becomes permanent. Once you lose the home, the daily presence, the bond, it's nearly impossible to claw it back. Ask yourself, how many fathers do you know who ever moved back in after being forced out?
All right, thank you. Given the admissions by the defendant regarding his drinking problem, I think it is in the best interest of these children that the mother have temporary physical and legal custody. I will refer this to the front of the court for an investigation regarding custody, parenting time, and child support, with the parties splitting the fee. That parenting time be as the parties agree. SoberLink or something similar might be a good tool. I realize the parties probably don't have a lot of money to go around, but that might be a way of ensuring that the defendant is sober during parenting time, because that's the court's biggest concern. I will grant and I will order that he be sober at any time he's with the minor children, and I mean completely sober, not even one drink. The plaintiff is granted exclusive use of the marital home and possession of one of the vehicles. The defendant is granted possession of the other vehicle so long as he is employed.
And there it is. The judge says it's only temporary. But what's temporary when the clock runs for months, even years? Before trial? For a teenager, that's their entire high school experience. For a father, it's the difference between raising your kids and watching from the sidelines. What do you think? Should courts have tighter limits on how long these so-called temporary orders last?
Certainly that is something could be revisited if he is not employed and has no immediate need then for a vehicle. And that the defendant vacate within 7 days, that the plaintiff will maintain the bills and expenses for the marital home temporarily. I will grant a mutual civil restraining order forbidding the parties from threatening, harassing, or abusing each other. Also including financial mutual restraining order, and the attorneys can or the plaintiff can draft that. Basically, both status quo financially needs to be maintained. And I believe that's it. Is there anything else?
Your Honor.
Oh, well, 1 second. Mr. Browning indicated that he might go to a hotel or something. If he does something like that, how would that be paid for? Is that something my client needs to?
No, he would. At this point, he would be paying for that.
Okay.
He just said he's employed. It's going to be employed next week. So,
Well,
and again,
can
all of
I
these,
say something?
all of these things can be worked out as this case progresses too. This is just a temporary initial order.